So what's in a name? Well, food for thought at least. Behind me is one of the great tourist attractions of the world, Ministers Island near St. Andrews, New Brunswick. Now that's Ministers, plural, not possessive, which is kind of interesting because Minister Andrews was just one person. And if it's his island, you'd think it would be possessive. But then again, I don't think he was a saint, so I don't know why the town is called St. Andrews. Someone later tacked on by the sea, and I'm not sure if that's its official name either. This island is famous for a couple of other reasons. The great Canadian railroad builder, originally American, Van Horn, William Cornelius Van Horn, built his summer cottage here, and by cottage I mean a 10-room palatial estate. And he had barns and cows and all kinds of animals and greenhouses and what have you. But the local folklore is he bought part of the island, then he bought a bit more, and who owned the rest of it? I don't know. How did Minister Andrews come to claim ownership of the island on a minister's salary? Well, apparently he bought it from United Empire Loyalists. Where'd they get it from? Don't know. Probably there aren't records. But one thing we do know is that the Beskotomakatis have been harvesting clams here for about 13,000 years. And we know that from archaeological evidence, middens, which are piles of clam shells that are preserved in a certain way. And you have to decide, what is it that you're most impressed with? A lack of an apostrophe, adverse possession, meaning you've just kind of been here for a while, folklore, or the archaeological evidence? It's an interesting question. And in many jurisdictions, you only have to go back a few decades in order to search title and have title to a property. And this is really problematic in a lot of our historical evidence that can be found.
There you can see it was a cold and windy day at Ministers Island near St. Andrews, New Brunswick, one of the great tourist destinations of all of North America, voted #1 by USA Today readers a while back, but perhaps I digress. I think our topic is a little more important than tourism. Ministers Island has an interesting history. Who owns it is a question that I'm asking, and Ian Peach, former practicing lawyer, now recovering at the University of New Brunswick and writing about Indigenous issues, may have a perspective. Ian Peach, your view.
Well, my view is that Ministers Island and the Bar Road that gets you there is ultimately owned by the Passamaquoddy. The courts have told us, for instance, the Supreme Court of Canada in 2014 told us in the Chukotka Nation versus Canada case that Indigenous peoples have title to all the territory they traditionally occupied, including, in this case, something like the Bar Road, where you can't occupy it 24 hours a day, 7 days a week, 365 days a year, because with the tides, it disappears sometime. But they used and occupied the Bar Road and Ministers Island, the Ministers Island that is the big island at low tide and the smaller island at high tide, throughout. This makes sense to me. I would compare it to somebody owning a home in Fredericton, where I live, and another home in Florida. Well, you own both houses, both homes, despite the fact that you don't occupy either one for the entire year. You know, why should concepts of ownership be any different for Indigenous peoples?
Well, let's go through the provenance of Ministers Island before we get back to Bar Road. 400 or 500 acres, I think, and I'm equivocating because it's obviously bigger when the tide is out versus when the tide is in. It was occupied by United Empire Loyalists briefly, then the king gave a grant to someone else. Then along comes Minister Andrews, who gave his name to the island, and William Cornelius Van Horn, the great builder of the Canadian Pacific Railroad. What can you tell us about that chain of provenance, let's say?
To be honest, the detail of that chain of provenance within the common law would require more archival research than I have had the opportunity to do. But I also don't think it matters as much, because ultimately, I think I'm not a practicing lawyer, as you say. I'm a reformed lawyer, so I'm not giving a legal opinion on this. But from my study of constitutional law, Aboriginal law, which is our constitutional law of the Crown's relationship with Indigenous peoples, the Passamaquoddy own all of this stuff. One might ask, well, didn't the British acquire it through treaty? And the answer to that is no, because in the Maritimes, the relationship between the Indigenous peoples, the Mi'kmaq, the Wolastoqey, and the Passamaquoddy, members of the Wabanaki Confederacy, and the British Crown, is governed by peace and friendship treaties. These were negotiated between 1725 and 1779. And the peace and friendship treaties are exactly what they say they are. They are agreements between the British and the Wabanaki nations to live in peace and friendship. They created a military alliance with the British against the French. The British created a trading relationship with the Wabanaki to secure that alliance and to create a stable economic relationship for both sides. But unlike the prairie treaties of the 19th century, the Wabanaki's lands, over which they had been sovereign and they remained sovereign, were never transferred to the British. That's why the Wabanaki are sovereign to this day, because they never gave up that sovereignty. They shared, but they did not transfer.
Now, you make a compelling case, as one would expect from a former lawyer. If someone were on the other side and arguing for the United Empire Loyalists or the King or Minister Andrews or the estate of Mr. Van Horn, I think that argument would have to stop at a certain number of acres, because I don't know ever in history of hearing about, or folklore, I've not heard folklore about any of those people owning the whole island or claiming to own the whole island. I thought Van Horn bought about 40 acres. I don't know how many Minister Andrews had, but it certainly isn't the whole thing, as was the case with the Beskotomacates. Does that have relevance?
I'm not sure it actually has relevance to my argument that the Passamaquoddy are the real owners at source. One presumes that when the original United Empire Loyalists came in 1777 and sought to settle, they would have made some arrangement with the Passamaquoddy. And from what I understand of Indigenous concepts of property, they wouldn't have been able to ask the Passamaquoddy for title. They would have talked to the Passamaquoddy about sharing the land with them. And the Passamaquoddy may well have agreed to share their land with these settlers. And they would work in collaboration with one another to allow each to live as they wish, without interfering with one another.
Well, again, your case is compelling, and I think that the trivial matters that I've raised actually support your case, because I don't think anybody other than an American interest that claims to have bought and owned the whole island in the early 70s, I don't think any of those historical figures have any claim to more than some number of acres of a 400 to 600 acre island. And I think that actually bolsters your case and weakens the case of the provincial government claiming ownership now.
Indeed, I would agree. I mean, when I look at the Chilcotin case in BC, there the Supreme Court of Canada said that Aboriginal title gives the Indigenous nation that is the title holder exclusive right to decide how the land is used and the right to benefit from those uses. Again, that makes sense to me. Thinking about land we own, homes we own, would any of us let anyone else decide how our house would be used? Of course not. So that land, which the Passamaquoddy used back 13,000 years ago, is theirs to use and benefit from. I mean, the one thing I don't like from the Chilcotin decision is that it allows the government to undertake activities on Aboriginal title land without securing the consent of the Indigenous title holders, if they can justify it as minimally interfering, whatever that means, with Aboriginal title, and if the activity is more beneficial than harmful.
Well, I'm going to use that court ruling next time I come to Fredericton to go jogging through your backyard, have a picnic there, and I promise I will be minimally invasive, and I'm doing it for my well-being. Is that okay with you?
That is precisely the problem with this justification test.
You're saying you'd have a problem with that?
Oddly enough, yes. If it's my property and you come and you ask me if you can do that, and we make an arrangement, and I say, sure, let's go for it, great. But if you come and say, I'm going to do this and I don't have to ask your permission because I'm not going to do you any harm, that's a problem.
Well, indeed, and there are rights of way that railroads have, and that doesn't confer title, and that muddies the waters a bit. But let's go back to Minister's Island on a cold and windy day, as I've said, and take a look at the Bar Road, which we've already made reference to.
This is under the heading generally of who owns what and how do you know. I'm looking over at the Bar Road, and it's not a road anymore because the tide is in, and Minister's Island is now an island as opposed to connected to the mainland by an isthmus. Who owns the road when it's underwater? Who owns the road when it's above water? Well, there are rights of way. Railways have rights of way. And that doesn't confer title. It just gives the railroad a right to pass that way. I'm not sure who owns that road. Now, here's something else that's interesting. Who owns the hard surface, we might call land, underneath the water when the tide goes out? Because that's a great, rich place to dig for clams, as I did when I was a boy. You might think that's a bit of an oddball question and a legal red herring, but in the 1850s in San Francisco, there were underwater lots sold. These lots became land when boats were scuttled, garbage was thrown in, and many of our urban areas that abut water have huge areas of downtown that used to be underwater. Now, who owns those and how do we know? In the city of Toronto, for example, there are 200 acres in dispute. There have been swaps among the railroads. Even the planning department won't verify who owns it. There have been legal cases, and most of it was once underwater. So who owns former lake bed that has been filled in with garbage, hydraulic fill, the earth that is used when you build a great big building? Well, the reason this case is going to be interesting is that on the West Coast there has been a case giving Indigenous people title to the clam beds and the tidal area. There's probably a legal term for it, but the land that exists only when the tide is out, and maybe the Beskodomokatis are going to get ownership of that piece of land and to be able to harvest clams there or manage the resource or maybe do nothing with it. Who knows?
Well, my point was the Bar Road is one way to get to Minister's Island, and it is underwater for a lot of the time, every day, and then it becomes a hard surface road. Now, it's called the Bar Road. It's not exactly a sandbar. It's full of large rocks, as you may have seen. Ian Peach is in Fredericton, an hour's drive away. Who owns that?
I think, again, fundamentally, at root, the Passamaquoddy on it.
Now, even though if archaeological evidence could show that they always came to the island by canoe and never used the Bar Road, would that have an effect on your opinion?
I suspect not, because I suspect if we had that kind of solid archaeological evidence, we would actually discover that while what is now known as the Bar Road was not used by the Passamaquoddy as a roadway, as we understand it, that territory, that land, when it was not submerged, was probably used for things. And the issue of what activity the title holders use it for doesn't matter. Neither does the fact that it is sometimes submerged so that the title holders couldn't use it 24 hours a day, 7 days a week.
And in fact, it could have been a hurricane or other storm that threw up a lot of that debris and made it maybe 3, 5, 7,000 years ago. So that muddies the waters yet again.
Indeed.
Now, for those who say, you know, what's this got to do with me? I think for anyone living on any of our coasts, the important thing is that when the tide recedes, there are clam beds there on what appears to be solid land. It's underwater when the tide is in, and those clams are a tremendous resource. Indigenous fishing rights are a known legal entity. So that's a rich resource that the Beskotomi Caddies may have, I hate to use the word ownership because that may not be the term they like, but dominion over or rights about. And that is an important economic matter, and that can affect all the coastlines of our country, wouldn't you say?
Indeed, absolutely. They would have had, I like your term dominion, they would have had the primary, the oldest use of those resources in that territory. And time matters in this stuff. The oldest title, what the common law recognizes as title, is the title that matters. So the fact that the Passamaquoddy were using that land first, before the Europeans ever arrived, and never transferred the land to anybody else, is all that matters. You know, I think back to the Supreme Court's decision in Haida Nation versus British Columbia, that the Supreme Court there said that Crown sovereignty over territory of the Haida Nation in British Columbia was only asserted or assumed, while the court also indicated that Indigenous sovereignty was genuine. This, to me, is the better way to understand the relationship between the British Crown and Indigenous peoples. That Indigenous peoples had real sovereignty, and the British sought to exercise power as an act of power rather than as an act of law.
And yet I have to raise the thorny little concept of adverse possession. If your neighbor is using part of your backyard and you put up a fence there, if both of you weren't sure where the lot line was, and it is used, I think in some jurisdictions, for 7 years by your neighbor ends up in effect, de facto, owning that small strip of property. Does adverse possession come into play, or does the treaty trump the whoever occupied that land for dozens of years?
Your example of adverse possession is legal because it has been integrated into the common law. But this is a different situation because treaties, as constitutional documents, and the rights of Indigenous peoples, the title of Indigenous peoples that come out of either the treaties or their prior occupation, trumps all of that stuff. Because they are constitutional in nature, they are more important. So their adverse possession doesn't trump.
So this argument that I can sort of hear in the back of my mind we've been here for hundreds of years, but we've been here for thousands of years, is irrelevant given the treaties and the constitutionalization of the effect of those treaties. That trumps everything, right?
Yeah, ultimately, crown title and the title that the crown can transfer to others and then be transferred among individuals in purchase and sale transactions has to give way to the underlying indigenous titles. And indigenous title holders do indeed have the exclusive right to decide how their lands will be used.
Well, Ian Peach in Fredericton, now that we've resolved that, I can just say I hope the Beskatoma Caddies allow me to continue to go to Minister's Island because it's a great spot. And I encourage everyone to go take a look at it and understand its history. Any final thoughts from you?
I too would be happy to return to Minister's Island. And in my ideal, I would return with Passamaquoddy representatives in alliance, in peace and friendship.
Super. Thank you very much for your time.
Thank you.